Businesses around the globe are under significant pressure and face uncertainty as a result of the global pandemic. Acting quickly is critical, and businesses should consider what tools they have available to them to reinvent, transform, and restructure. Hello and welcome to the latest edition of Kalo's Independently Speaking podcast series. My name is Cassandra Ronaldson, and I'm a Senior Manager in Kalo's Cayman Islands Restructuring team. So for any new listeners, Kalo is an independent insolvency and restructuring practice with offices in both the Cayman Islands and the British Virgin Islands. Today, the podcast is going to provide some insights into the Cayman Islands restructuring regime and take a look at some of the proposed changes. We hope this is a series that will assist those that are considering their options in the wake of the global pandemic. I'm very fortunate today to be joined by Rocco Cecere. Rocco is an offshore commercial litigator and a partner at the law firm Collas Crill. Welcome, Rocco, and thank you again for your time.
So Rocco, you were practicing law following the 2008 financial crisis. Whilst we're still early days, from a restructuring perspective, do you think there are any key differences or similarities to what we might expect?
We are still in early days, so it is difficult to tell, but one similarity that we have now as we had in 2008, I think, is it is taking some time for matters to work their way through the system. But that being said, the ABI reported that Chapter 11 filings for April were up 25% year on year in the US, and that figure for the end of May increased to 46% increase year on year. So there is a real uptick in restructuring work, at least in the US, and some of those restructurings relate to some really high profile companies in those industries that have most been impacted by COVID. So for example, we've seen aviation hit very hard, and Virgin went into VA in Australia, Flybe into administration in the UK, and more recently LATAM Airlines went into Chapter 11 in the US, and there are other sectors that have been hard hit, like oil and retail and car rental and tourism. But I think even with those numbers that I've just outlined, I think that it's fair to say that this is still just the tip of the iceberg. I
understand there's actually a bill before the Legislative Assembly to change the companies law, and those changes would allow a company to restructure under the supervision of a restructuring officer, a process which would actually be outside of the liquidation process. But I think perhaps before getting into those changes, Rocco, would you mind explaining for the listeners' benefit the current restructuring regime in the Cayman Islands and how it has developed?
At the moment, the Cayman Islands doesn't have a dedicated restructuring regime to rehabilitate distressed companies like the Chapter 11 proceedings in the US or the UK's administration procedure. However, a distressed Cayman Islands company may enter into a scheme of arrangement to restructure its debt. And in broad terms, a scheme is a statutory and court-supervised procedure by which a company can make a compromise with its creditors or other stakeholders. And they're really flexible tools, and they can be used for a bunch of different purposes, including mergers and group restructurings. But they're most commonly used to rescue distressed companies and to avoid insolvency. The problem is with schemes, however, is that the commencement of the scheme process doesn't itself trigger a statutory moratorium. So a company entering into the scheme process is entirely vulnerable to, say, a dissenting creditor kind of derailing the process entirely by coming in from the side and suing the company and really throwing the scheme out of whack. So that's where provisional liquidation comes in. Traditionally in the Cayman Islands, provisional liquidators were appointed on an interim basis just to protect the company between the filing of the petition and the appointment of a permanent liquidator. But there was a really innovative decision about 20 years ago in Cayman, which held that the Cayman court had jurisdiction to appoint a provisional liquidator to also effect a restructuring, and there followed some statutory codification of that. So since then, a restructuring provisional liquidation has been a really familiar feature of the company's law here in the Cayman Islands.
So I guess this really begs the question, with so many successful restructurings under Cayman's belt and even other jurisdictions taking Cayman's lead, Rocco, why do you think it is that we actually even need to change the law?
Well, I think a couple of reasons. As I said earlier, to get to a restructuring provisional liquidation, you need to petition the court to wind it up. And under Cayman Islands law, that petition can be brought by the company or a creditor or a shareholder, but it's been held that unless there are specific powers in the Articles of Association that allow a director to bring that petition on behalf of the company, they need to obtain a resolution of shareholders to bring that. So that puts a director in a really difficult position, especially if they're in control of a distressed company, because many of the Articles of Association for these companies don't have an express power, and it can be really hard to get shareholder interest in these companies. They don't have an economic interest in the companies by default anymore because they're insolvent, and often the shareholders are kind of spread across the world. So it's very difficult for them to obtain the necessary resolution. The other issue, I think, is this kind of inherent paradox in having to trigger a insolvency procedure to have a company be rescued, and some of the kind of the taint that goes along with that, Cassie.
Rocco, would you mind setting out some of the proposed changes to the company's law?
The bill as drafted effectively permits directors on behalf of a company to petition directly for the appointment of a restructuring officer, which is an entirely new office created by the draft bill. So this deals with three main issues straight away. Firstly, there's no need to go through this two-step process of looking to petition to wind the company up and then take a bit of a detour for a provisional liquidation. That's the first point. The second point is that directors are empowered to make that application on behalf of the company. So you get around the difficulty in not having to deal with the workaround that I mentioned previously. And I think thirdly, and just as importantly as those two more legalistic issues, is that we have someone called a restructuring officer who's isn't a liquidator, who will be a licensed practitioner, who will be in charge of implementing the restructuring. The other main features of the draft bill are that it creates a statutory moratorium upon the appointment of the restructuring officer, which retains the status quo. And like the current regime, the restructuring officer is only given the powers that are provided under the order. So parties can be flexible, and the court has some flexibility to kind of design the necessary powers on a case-by-case basis. So this light touch restructuring remains possible.
Do you envisage any issues with the potential changes to the law?
Well, I think on the whole, it's really positive news. It puts Cayman and our restructuring regime on a much more modern and firmer footing, and I think it's going to make the Cayman Islands an even more attractive jurisdiction in which to restructure. One point that comes out of the draft bill is that the draft bill perhaps understandably removes the old provisional liquidation route to a restructuring. And there may or may not be concerns that, after having effectively educated foreign attorneys and foreign courts and got them comfortable with provisional liquidators who are often recognised, for example, in Chapter 15 proceedings, that we're kind of now, we now have a new office and a slightly new regime that is going to be unfamiliar to both foreign attorneys and foreign courts. I'm not sure how much of a problem you think that'll be.
Hopefully the foreign courts can take comfort from the fact that restructuring officers are court-appointed officers whose powers and functions are granted by the court, limited by the court, and are subject to the court's oversight. But I'm more than sure that the lawyers are capable of navigating these issues or non-issues should once they arise.
I do agree with that. I think we will be able to educate our colleagues in other jurisdictions.
I guess all we can do is wait and see. But I know that these changes, as you said before, would be welcomed by the industry and would further strengthen the Cayman Islands as an international jurisdiction. If we leave off now, we could pick this topic up perhaps once the proposed bill comes into effect.
That would be great. That'd be great, Cassie. I'd be only too pleased to talk to you again about that.
Thank you, Rocco. Thank you again for your time, and I hope everyone that's listening that their families are keeping well and safe at this time.